So within divorce and financial proceedings, parties need to disclose all assets in which they have an interest, and that includes property assets, it includes business assets, it includes savings and investments, pensions, and any assets held in trust or held on behalf of a party by somebody else. The court will make a distinction between matrimonial assets, which are assets which were accrued during the marriage, and non-matrimonial assets, which accrued either before the marriage or after it ended. So in terms of the division of a family's assets on divorce, the family court will first look to divide the matrimonial assets equally. And if an equal division of the matrimonial assets meets both parties' needs and the needs of the children and is overall a fair division, then it's very likely that the court will make an order in those terms. However, it may be that the circumstances of a case mean that an unequal division of the matrimonial assets is necessary, and the court does have broad powers to do that. It might be possible in some circumstances to ring-fence non-matrimonial assets from division, but that will depend on the circumstances of a case and is something that you should take advice about. So parties to divorce proceedings need to provide full and frank disclosure of their current financial position and also provide documentary evidence to support what they say. The duty of disclosure is an ongoing one, and that means that if your circumstances change during the course of financial proceedings or negotiations, then you need to make sure that you update the other party and inform them of that. The court has broad powers to make orders in relation to a family's finances and property on divorce, and that includes orders in relation to the transfer or sale of property, lump sum orders payable by one party to another, the transfer of shares held in a business, the transfer of pension interests, and also orders can be made in relation to trusts and interests held in trusts. As well as making orders in relation to capital assets, the court can make orders providing that one party should pay maintenance to the other, whether that's for the benefit of the other party or for the children of the family. Court proceedings aren't the only way of resolving issues between parties who are getting divorced. I would urge anybody to consider alternative methods of dealing with the disputes, such as mediation, having roundtable meetings between solicitors, or potentially considering arbitration. However, there are of course cases where court proceedings are both necessary and that's the right step to take. It's important to bear in mind that unless you take steps to resolve the financial position at the time you get divorced, then it's possible that one party might try and bring a financial claim against the other, even if it's several years after the divorce proceedings have concluded. For that reason, it's really important that you take steps to resolve the finances at the same time as dealing with the divorce.